The machine learned to create images from nothing, but it could not unsee what it had seen. That was the fatal error. When Stable Diffusion emerged from a collaboration between researchers at CompVis, Runway, and later Stability AI users, found a ghost in the code: the faint, distorted sigil of the Getty Images watermark. According to the complaint filed in the High Court of Justice in London and the U.S. District Court for the District of Delaware, Stability AI had allegedly trained its models on millions of Getty Images photographs without authorization, then stripped the copyright management information. It left a forensic fingerprint. That ghost became a central subject in Getty's trademark infringement claims, alleging the AI models infringed by generating outputs bearing the watermarks. The attempt to erase the origin of the data had, instead, magnified it. This wasn't just a technical glitch. It was fuel for a broader legal offensive, one that initially spanned copyright, database rights, trademark, and passing off claims, but where the primary copyright and database rights claims were abandoned during the course of the UK litigation, while secondary copyright infringement and trademark claims remained central, though the passing off claim added nothing beyond the trademark issues. That vulnerability was born from Getty's greatest strength: the transformation of photography from a creative art into a meticulously constructed intellectual property licensing machine. A machine built not on glass plates or darkroom chemistry, but on data. The company's value was never just in the images themselves. It was in the system built around them. Each of the hundreds of millions of assets in its archive is a dual entity: the copyrighted visual work and its attached metadata. Think of it as a deed attached to every square inch of digital real estate. Central to this system is the Getty Images watermark. Far from being a simple brand stamp, the watermark functions as Copyright Management Information (CMI), a designation carrying specific legal protections under the Digital Millennium Copyright Act. This legal framework makes the intentional removal or alteration of that watermark a separate and distinct violation from the copyright infringement of the image itself. 2 crimes, 2 penalties, per image, and Getty's archive held 12 million of them. The lawsuit against Stability AI alleges the unauthorized copying of over 12 million protected images. Under United States law, this could expose an infringer to statutory damages of up to $150,000 per work. Critically, the alleged removal of the CMI from each image could trigger additional damages of up to $25,000 per violation. A figure that, multiplied across the archive, would dwarf most company valuations outright. This dual-layered legal structure transformed the Getty archive from a simple library into a fortress, each image guarded by significant financial deterrents. But this fortress was designed to police a world of human-scale commercial clients: licensing teams, ad agencies, magazine editors negotiating terms. It was not prepared for an automated actor that viewed its entire collection not as a catalog to be licensed, but as a dataset to be ingested. And that miscalculation cuts both ways, because the very mechanisms built to protect the archive in the old world became the sharpest weapons in the new one. The alleged infringement didn't begin with Stability AI. It began with a public index, the Large-Scale Artificial Intelligence Open Network, or LAION, a German non-profit's academic project. Not a library of images, but a map. A massive, open dataset of metadata, providing URLs to billions of image-text pairs scraped from across the public web. A tool for scientific exploration, assembled by crawling and linking to publicly available images rather than obtaining individual licensing agreements from rights holders. And in a separate dispute brought by photographer Robert Konechka, upheld by the Higher Regional Court of Hamburg as permissible under text and data mining exceptions. Court-documented facts establish that Stability AI utilized this map as a blueprint, a card catalog for a library that didn't exist yet. Its datasets, like LAION5B, comprised of web links to publicly available images used by Stability AI to train its model. The training drew on massive internet-scraped datasets, including, the suit claims, over 12 million images belonging to Getty. Here lies the core tension. A massive, internet-scraped dataset becomes the raw input for an engine that is both open source and commercial. Getty's archive wasn't licensed. It was ingested. The abstract threat of scraping became a concrete, and very public, failure. When users generated novel images with stable diffusion, a flaw emerged. A ghost in the machine. The mangled, yet unmistakable silhouette of a Getty watermark. The model had learned its source material so well it could not forget its signature. The evidence of its unauthorized training was now on display for the world. The case pivoted from abstract data theory to forensic certainty with one artifact, the phantom watermark. Generated images from stable diffusion appeared warped, bearing the spectral remnant of the Getty Images logo. This wasn't a clean copy, it was a distortion, a deep, learned echo. It was the model's confession. According to the complaints filed in both the UK High Court and US District Court, the visual evidence became a component of Getty's trademark infringement claims. The filings also alleged DMCA violations related to copyright management information, though the court later found Getty failed to adequately plead the requisite intent for those claims. Section 1202 of the DMCA prohibits the intentional removal of copyright management information. Getty's filings argued the distorted outputs were direct proof. The watermark's CMI had been present in the training data and was processed, imprinted, then regurgitated. The phantom wasn't an accident. It was a ghost of the original, creating a direct forensic chain back to the archive. Per the court filings, the US litigation advanced past initial procedural challenges. A critical foothold. The fight now moved beyond the lab. The battlefield was the courtroom. And the synthetically generated watermarks became central evidence in Getty's trademark infringement claims. The passing off claims standing or falling with them, forcing Stability AI to confront this visual proof head-on. Faced with Getty's allegations, Stability AI held firm. The model didn't copy, it learned, non mods. It did not store or reproduce the images, they argued, but absorbed patterns in an abstracted form. Their goal was to reframe Stable Diffusion not as a copy machine, but as a student of visual culture. Getty's legal team, meanwhile, had leveled another charge, separate, technical, and brutally specific. The DMCA claim invoked Section 1202, which prohibits the intentional removal of copyright management information. Even if the core copyright arguments faltered, Stability could still face liability for stripping the watermarks during training. This shifted the entire battle. The debate was no longer philosophical, it was forensic. The conflict unfolded on two distinct fronts. In the UK, a High Court judge initially found Getty's claim had a, quote, real prospect of success. But a later withdrawal of the training data claim there narrowed the trial's scope, contracting that battlefield. In the United States, however, the core lawsuit continued, though the district court dismissed Getty's DMCA claim without prejudice, finding Getty had not adequately pleaded the requisite intent. As the UK front retreated, the global stakes of the unresolved American case only escalated. The industry was watching. Which legal precedent would hold? The philosophical shield of fair use, or the claim that training on copyrighted works without permission is infringement? The litigation's trajectory reveals its true significance. A broad, dual-jurisdiction offensive contracted into a focused American legal standoff. The UK front narrowed. The US case crystallized around the DMCA. This wasn't a retreat. It was a precision strike. The philosophical debate over fair use. The argument that AI learns like an artist met a technical wall. The DMCA claims sidestepped that entire conversation. It alleged not just theft, but evidence tampering. The intentional removal of watermarks and metadata. That changed everything. The central issue is no longer the act of ingestion. It's the verifiable, machine-readable integrity of the data itself. A new standard of diligence is being forged. The UK government is watching this case as it drafts its own laws. The frontier of technology has moved from the lab into the harsh light of legal accountability. Regardless of the final verdict for Stability AI, a lasting precedent is set. Every AI artifact is now linked to the legal scrutiny of its training data. That distorted phantom watermark became more than evidence. It was a symbol. It proved digital origins leave indelible traces. The era of opaque data sourcing is ending. The question is no longer just who gets to scrape what. It's what invisible signatures of ownership are baked into every model's foundation. And who will be the first to find them?